morning, and thank you very much for joining us on this podcast. There are a number of things that we thought we'd cover in this discussion. First of all, if I could just introduce you to Diane Loveday and Sanaz Nami Roshan. And we're going to be just talking about the processes that are involved for parties when they want to be able to resolve matters, both in the context of financial matters and also children's matters. So thank you very much, Diane and Sanaz, for being available this morning.
Thank you for having me. Appreciate it. Yes.
And so, look, I think one of the things that we try and work hard on, Diane, as lawyers, and this may be surprising, is to try and get as much of the issues that need to be resolved by clients without the involvement of lawyers. Because clearly what they're dealing with is much broader than just a legal problem. They're dealing with emotions, they're dealing with expectations, they're dealing with children. There's a whole lot of things. And perhaps if we could just talk about the various processes and terms that are involved to assist people understand those, because they are outside, if possible, the legal process to assist parties. So perhaps if you just want to talk about that to start with, to put things in context for us.
Okay. So I suppose would help to clarify my role within the family law process. So my official title is Family Dispute Resolution Practitioner. It's a bit of a mouthful. And we work with clients. My preference is to work with clients at the very outset of their separation journey to do exactly that, David, to help them clarify the best possible pathway for them, because there are a number of pathways. There's, as we know, there's litigation, there's collaborative law, there's FDR mediation. That's just three of possible. I think there's at least 10 or 15 different pathways. So helping, our role in those early stages is to help people understand exactly what all their options are, help them understand their rights and obligations. Now, it's important to know that we don't, while some of us have law degrees, we're not at this point working as lawyers, so we can't give legal advice, but we give lots of legal information. We direct people back to lawyers to ask specific questions in relation to their matters, and we just help clarify for them what they might, and answer the questions, basically. If I keep it, it's about, very rarely do people come to this process having experience working with lawyers, especially at the level of family law.
Sure. So just on that, so I know you're an FDRP, but who can be an FDRP?
So an FDRP requires a qualification at a postgraduate level. So we do a graduate diploma in family dispute resolution, and there's obviously the practical area of that, but there's also 50 hours of supervised work. So in order to do this work, you have to sit with other FDRPs and learn the ropes, if you like. So we are also registered with the Attorney General's Department. We have a whole section about our compliance requirements in the Family Law Act. Mediation is compulsory now across FDR mediation is compulsory across all areas of family law now, including property and children. So we have a compliance requirement. We must be registered. We have to do continual professional development. We have to be insured. We have to have a complaints authority. So it's a heavily regulated. It's nowhere near as regulated as you guys. I get it, and our obligations and our compliance requirements are nowhere near as strident as lawyers. But we still have that level of coverage to protect people who are coming into this in a very vulnerable state, and to make sure people get the appropriate advice and support.
And
can I just ask you, sorry, David.
I'll say after you, Sanaz.
I was just going to ask the process of FDR. Can you take us through what that actual process is? So a client comes to you. What's the process that's involved?
Okay, so there's two distinct streams. So there's FDR one with a firm like ours. and understanding that majority of our clients have had maybe a conversation with a lawyer, may have lawyers sitting in the background as support, but they are not lawyer represented in our process. We can offer lawyer represented FDR, but we try and encourage people to resolve their issues on their own first, knowing full well that if this process fails, litigation is still available to them. So if you then, the other option is to be with lawyers and to have a lawyer-assisted FDR process. So I'll just talk about my process, which requires us to see parties individually. So they come in for what we call an intake interview. Each of them comes in on their own because we need to understand, and it's quite a unique part of what we do is that we hear both sides of the story. So we get to meet both clients. And hear their stories, find out where their issues sit, find out what it is they want to achieve, what they think they are entitled to, and help them understand and get started in this process. Once we've met with both of them, we then bring them in for mediation. Now, again, in our practice, we separate parenting and property because one, we don't want to put people under that level of stress. I understand.
So into two sessions, is that right? Into two sessions?
At least. We like to get things resolved quickly, but sometimes it requires more than one session to resolve a financial mediation, for example. Or with parenting, because we see people so early in the process, there's so much they don't know. That they don't know how to be good co-parents. I'm trying to help them understand how to be good co-parents. So there's a whole bunch of new learning that needs to be discussed and processes put in place. So we produce a thing called a parenting plan, which is an in-principle document, not unlike a heads of agreement if you were using lawyers, that can be drafted into orders if clients want. But we generally recommend for parenting that the real strength of a parenting plan is that it's quickly and easily reviewed. So, utilize your mediator, let your mediator be part of your journey through separation. And if you need to come back and review a document, change something, if something's not working, it's a much simpler process than if you have orders in place. Though ironically, if you have orders in place, the first thing you have got to do is come back to mediation before you can get your orders changed. So I just come back to this. People say, why should you mediate? I go, well, why wouldn't you? It doesn't preclude any other element of litigation or any other process in the family law process, but it might help you resolve some of the more entrenched or difficult issues early on, so you then can move forward more freely.
Also, it can narrow the issues as well. If you don't ultimately come to an agreement, you can significantly narrow the issues as well.
Yeah, absolutely. And I hear that a lot from all the lawyers that we work with, that when you get our fails, they are often in a much better position than if they'd come to you at the very beginning of the process.
The other advantage of your process also, Diane, at doing that is that education is absolutely crucial for understanding, for example, the needs of your children.
Yeah.
And so often parents will say, well, I want to share care, but if it's reframed as you want the best arrangements for your children, and understanding the needs of a 1-year-old versus an 11-year-old are going to be different, it enables you to have that discussion, because I have to say that sometimes dealing with lawyers, they don't necessarily, all lawyers doing family law, I'll make that distinction, don't necessarily understand the importance of the developmental issues for children, and you can provide that educative part of the discussion, which is crucial to making good decisions for children.
Completely agree. Care arrangements for a 1-year-old are very different to care arrangements for a 5-year-old or a 10-year-old. But yes, it's something we take very seriously here, is the focus on the child and the care and well-being of the children. As do, I understand that everybody feels that they are, but your process is by nature adversarial. And that makes it difficult then, and you act under instruction. And I'm sorry, I'm telling you your process, but the difference in the law process is, I'm not acting under instruction for either of the parents. I'm not there to represent the parents. We actually interpret especially with the changes in the legislation, the recent May 6 changes, that we are required to advocate for the best interests of the children of the relationship. And even in financial matters, and we take that very, very seriously.
And the reality is the court is just a process. It's not something that gives you something better that you can get through mediation. And what you're trying to do, to some extent, one judge once said that they're not children's orders. Orders about children are about regulating what parents do. In other words, giving them the structure to be able to do the parenting. And the other advantage is that even if you have a court order, you still need to discuss what parenting looks like. That gives you the scaffold, that gives you the structure, not the actual ability to have important discussions about, well, for example, what time the iPad goes off at night during the school week.
Yeah. And it's often those really small details that will derail a conversation if you don't have somebody helping you manage it. You won't tell me how to parent my children sort of conversations. Well, let's find some common ground on this. Let's have a talk about the pros and cons. What's in the child's best interest here? How can I help these people shift their focus back to being angry with each other and back to being what's in the best interest of our children? Yes.
I was just going to ask, one of the things that Sanaz and I see as lawyers is we get people coming in saying, I want a Section I certificate. How do I get a Section I certificate? So
I was just about to say that.
Sanaz, if you just say what that is, and then perhaps Diane can talk about what that means for her when she gets told, give me a Section 60I certificate.
Okay.
So I guess a Section 60I certificate, and David's absolutely right. We get told, how do we get one? What's the easiest way of getting one? Where do we go to get one? And it's not getting one, it's actually going through the process of trying to resolve things amicably through you and that process. That's the vital part of it. And then if that process does not work, then you issue the Section 60I certificate. So a lot of clients just think you can just get this Section 60I certificate, but there's an actual process involved.
Absolutely. And we do often get phone calls. My lawyer has told me I need to get, fine, okay, but this is what we need to do in order for you to get that certificate. And as I explained, so that we must start at the very beginning. Even if people have been through mediation through another provider, we don't have access to their files. Their files are completely confidential. And it's probably a really important point to make when you're dealing with an FDRP, that the conversations and the process is completely confidential. So it cannot be shared with anybody unless the clients give us permission to do so. And that includes the family court. So you can actually have a really safe conversation in this space, knowing it's not going to be weaponized. So even if they come to us and they've been through one of, say, the government-funded providers, we can't get access to those files. So they have to start from scratch. So we do the intake interviews individually and then bring them together to actually mediate. And I've got to admit that I find issuing 60I certificates basically a fail. I don't think I don't know that I'm serving anybody in that space because, as you guys would know, going to court is often a lose-lose situation. Very rarely is it a pleasant experience for anybody. So, trying to keep clients out of that space is something I'm again quite passionate about.
Well, rest assured, from my perspective, when a client comes and says, I'm not one of those lawyers that says, go and get your Section 60I certificate at all. I tend to always tell my clients to go through that process, because if they can resolve things through the process of FDR, then they should. It's cost effective, it's not mentally draining, and litigation should be their very last resort. And to actually not think about the Section 60I certificate at all. Go through the process and resolve it.
Yeah, yes, and you know, it's no secret that I've had a relationship with family law for a long time, because as a law firm, you do have that philosophy that marries beautifully with what we do, and we work. We're complementary professions, if you like. It's a complementary process. We're not at odds with each other. We're not competing against each other. I mean, it's an $11 billion industry, for goodness sake. It's not like so if we look as professionals, if we look at us as complementary in the process of family law, and each of us has a role to play, ultimately for the benefit of the client, resolving these issues as quickly and as amicably and as cost effectively as humanly possible, then we all have the same goal in mind, which is great.
Diane, we actually are getting close to the end of time, but I've just had a question come in from someone. If I give you that question, or the gist of the question, if you could answer that. What's the difference between an FDRP practitioner, someone who does that, and a mediator? And where does that sit? Are they different process? If you could just talk a little more about that, because that would be useful, because that's a term we also use a lot in family law.
So I suppose basically anybody can call themselves a mediator, sadly. There is a certificate qualification to become a mediator, and you do that certificate qualification through the Mediation Standards Board of Australia. And they are trying to give that certificate a bit more bite, but ultimately it really does cover off everything else other than family law. Like the new name for it, and I'll check my notes here, is Australian Mediation and Dispute Resolution Accreditation System. FDR is not mentioned there at all. And if we think in terms of mediation, alternate dispute resolution is used through all areas of dispute resolution in all businesses. They're mediators, but to work in the family law space, we need to have an FDR qualification. It's only FDRs who can issue the 60I certificate, for example. Yeah. Now, once you get into litigation, that's a different situation, and there are often barristers or lawyers who are acting as mediators with or without the FDR qualification, and they're often very capable, and you know, they're used a lot. And for more complex matters, absolutely, and I think that's an important point. We have to understand our limitations as FDRs. Yeah, complex matters or high risk matters, matters where there's lots of excessive family violence. These are areas that it is often better handled by professionals who can have a bit more. I often use the word gravitas, because they carry a bit more weight. A barrister carries a bit more weight in those circumstances. So that's a different level of mediation. And some barristers have the FDR qualification, some don't. Some have got it and don't keep it read, and that's fine. But the distinction effectively in relation to the difference between FDR and mediation is that mediation, anybody can call themselves a mediator, but only those people who've done the FDR qualification, are registered with the Attorney General's Department and maintain that qualification, can call themselves a family dispute resolution practitioner.
Thank you very much. Well, that's just about time. So thank you very much, Diane, Sanaz. And I think that there's still so much more that we haven't covered that we might organise a couple more of these to pick up on some other specific topics.
That would be lovely. Thank you so much. I've really enjoyed this, and lovely to meet you, Sanaz.
Thank you. Thank you. Lovely meeting you too.